Welcome back. The Apex Court entered day 6 of hearing petitions regarding the demand for marriage equality in India. The centre requested the top court to consider leaving questions raised in the pleas seeking legal sanction for same-sex marriage to Parliament. The top court has asked the centre to find a way to give same-sex couples basic social benefits like joint bank accounts or nominating a partner in insurance policies, even without legal recognition of their marital status. The top court appeared to accept that legal sanction for same-sex marriage is under Parliament's domain. The remark comes as the court has been hearing petitioners who have argued that denying them the right to marry violate their fundamental rights and result in discrimination and exclusion. The arguments are set to resume next week on the 3rd of May. Joining me here on the program is Sanjay Hegre, Senior Advocate. Very good evening, Mr. Hegre. Always good to have you with us to explain to us.
Thank you, Afrida, for having me.
The full context, Mr. Hegre, as you always do, and that is why we wanted to have you on this subject. Because, you know, what we want to understand really is that, of course, some very, very striking arguments made by the centre explaining why Special Marriage Act cannot be applied, why this same-sex marriage cannot be assimilated within Special Marriage Act, Mr. Hegre.
Well, the centre is now arguing. The court has heard the petitioners out. And please do not go only by court observations. Sometimes courts ask questions, make observations, only to test the strength of the argument on either side. So the centre has said, look, it's not a question of only reading down one provision of the Special Marriage Act. The suggestion which was made to the courts was that, okay, leave aside the religious laws, the Hindu Marriage Act and the Christian Marriage Act and things like that, but please concentrate on the Special Marriages Act and say that any two people who are not otherwise married can get married. So so in response to that, the centre is saying, look, it's not a question of only reading down a few sections and that the rest of the law can automatically fall in place. There would have to be so many changes that, in fact, the court would be getting into legislative territory. So therefore, let Parliament do its job. So the court is asking the centre, let's assume that you're right. Let's assume that we do not strike down the Special Marriage Act or do not read it down in a manner which allows for same-sex marriages. But can you come up with a counter proposal? Can you at least have some kind of recognition of stable same-sex relationships, which are very akin to marriage, but may not be marriage if you say so, but which will give the two partners all the rights that partners in a religiously sanctioned or in marriage as is currently defined, all those rights that a couple have, this the same-sex couple must also have. So
Right.
also because there's going to be a break in arguments over the next week because one of the judges is traveling, and there is time till the 3rd of May when arguments begin again.
But you know,
the centre, you use the time to come up with a solution.
Yes, yes, we heard that side of the argument, but there's another very crucial point here, which lawyers who have argued in favor of same-sex marriage say that it's simply about changing the nomenclature a bit, use the word person, use the word spouse, and things can be resolved. Except for rape, everything else, it seems, can be accommodated with a change in the terminology, which can be easily done. And like you said, maybe, you know, read the Special Marriage Act to interpret it in that way and change the terminology around it.
You can't necessarily change terminology. You can only interpret existing terminology to also include something or to exclude something. Because if once you start substituting words, then you are again getting into the field of legislation. So there has been an argument that, you know, you can read down the section or expand the section to say to cover all kinds of people marry.
Yes.
But then there are other consequences of a marriage also, no? It's not only the marriage. It's life thereafter that also has to be regulated. This couple, a same-sex couple, obviously cannot procreate through the usual means. Now, supposing they adopt, and then supposing later they want a divorce, who is to have custody? Between a man and a woman, you might still say that a woman may have custody, but when there are two women involved, which of the women is to have custody?
Yes.
Or when there are two men involved. So there are several problems which would need definitions.
Yes.
And it's not as if you can just change one word and then say, okay, everything else will automatically fall into line. That's not how it is.
Yes,
How
but
the law as currently framed is.
Yeah, I mean, it has also now, of course, been said that the center has brought in the incest argument, the polygamy argument, saying if you stretch the sexual autonomy argument too far, tomorrow there'll be people asking to legalize incest, asking to legalize polygamy. So, therefore, we do not want to tread into that territory. Do you think that's a valid argument?
Well, almost every argument is valid. It is which arguments get accepted, which arguments don't get accepted. And sometimes arguments also go on that Latin principle of reductio ad absurdum. That is, you stretch an argument to a breaking point of absurdity. So I do believe that at least insofar as the incest argument was concerned, the Chief Justice said, no, you don't have to stretch it that far. Because ultimately, incest is also something of one's volition. The argument in same-sex is that it is not something entirely of one's volition, but it is more a matter of orientation. And insofar as orientation is concerned, where people can't help it, should such people not also have equal rights to have a marriage or something close to approximating a marriage? Now let me do the reductio ad absurdum bit.
Okay.
Now, supposing I were to say that marriage can be only between right-handed people. People who are left-handed cannot get married. Would that be? There is a principle of differentiation, but would that be a valid principle for differentiation? So you can't necessarily say that any particular person with orientations that are not of their own volition should be denied the dignity that lies in marriage.
Right. Which is why somewhere does it then boil down to denying a fundamental right to those individuals who are atypical in their sexual orientation? Do you think that ultimately the courts come in because it is a matter of the right to equality? Even though today it seems the court has also in a way indicated that a lot of it lies in the domain of parliament. But in this aspect, when the argument of fundamental rights come in, don't you think that the courts have a job to do there?
Well, very, very long ago, in the beginning of the Constitution's interpretation, Justice Patanjali Shastri wrote that judges are like sentinels on the qui-vive, always zealous in their protection of the fundamental rights. So yes, if you prove a fundamental right, and it doesn't matter whether you are in a minuscule minority or whether you are in a substantial minority or you are in the majority, if there is a right, and it's a fundamental right which has been assured by the Constitution, then courts are tasked with the job of ensuring that right gets recognized and is enjoyed by the person asserting it.
Yes. On that note, Mr. Sanjay Hegde, thank you so much for joining us. I think we covered all the important aspects of the arguments placed before court today. Real pleasure. to have you speak on my show. Thank you.